In 2016, Hillary Clinton had won the statewide popular vote in Washington state, and so the slate of presidential electors that had been nominated by the Washington State Democratic Party were appointed as electors. State law specified that they were required to cast their votes in accordance with the outcome of the popular vote in that state. But 3 of them didn't. And so under state law, they were each fined $1,000, and they appealed those fines up through the state courts in Washington, ultimately to the U.S. Supreme Court. There were really 2 related questions the court was dealing with. First, can states require their electors to cast their electoral votes for the candidate that won the statewide popular vote within the state? And then a second related question was, are there limits on the enforcement mechanisms that states can adopt for these types of elector binding laws? The electors argued primarily that the original intent underlying the creation of the Electoral College was that electors would exercise their independent judgment about who should be president. And they were able to point to various excerpts from the debates surrounding the ratification of the Constitution. And they basically said it would defeat the point of the Electoral College if states could simply direct their electors to vote in a particular way. They also pointed to particular words in Article 2, and they said that the very notion of a vote itself implies that the person casting it has discretion as to the candidate for whom it should be counted. The state of Washington raised several arguments. First, it argued from a textual perspective that there simply weren't any limits in the Constitution as to a state legislature's ability to bind electors or to require them to cast their votes in a particular manner. That since the Constitution was silent on the issue, there wasn't a basis for imposing restrictions on a state legislature's ability. It emphasized Supreme Court precedents that had held that legislatures have broad plenary authority concerning the appointment of presidential electors. And so building on Ray versus Blair, the state said if a state can require electors to pledge to cast their electoral votes in a particular manner, it would be highly unlikely that the Constitution prohibits states from enforcing those pledges, whether through fines or through removal mechanisms. The court ultimately held that states may bind their electors, and it affirmed both Washington state's decision to fine electors who violated those requirements, and in the companion case Baca, it affirmed the state's decision to simply remove electors who voted for the wrong candidates, disregard their votes, and appoint replacement electors who would cast their votes in accordance with the outcome of the election within that state. Justice Kagan acknowledged that many framers may have subjectively intended that presidential electors exercise their independent discretion, but she said there was no basis for the court to enforce those unexpressed subjective personal intentions, that the only thing the court could do is enforce the text of the Constitution, and nothing in the Constitution's text established or guaranteed electors' independence or electors' discretion. All of the justices agreed with the conclusion that states are free to bind their electors and to enforce those requirements. The decision promotes federalism by giving states broad discretion to regulate the manner in which their presidential electors cast their electoral vote. And it reaffirms authority that many states have been exercising for several decades as to the manner in which electors will ultimately vote for president.